things. It's not that hard. Just follow the rules. You may not like them. I mean, when you never show up, it's pretty much like you're just flipping.
Ouch, that's one way to start a hearing. When a judge compares your absence to giving the court the middle finger, you know the mood in the room just changed. Question for you. Do you think this opening makes the judge more likely or less likely to show leniency?
Us off, you know, for giving you an opportunity. All right, ma'am, you're Jamie Story. And this is cause number 23, DCCR 1546. Ms. Story was placed on probation February 25th of this year for the offense of theft of property with previous convictions, and that was enhanced to a third-degree felony. The sentence was a 10-year term in prison that was probated for 10 years. Motion to revoke was filed. We were here before, and Ms. Story pled true to all of the counts, 1 through 7. I've received the updated report. Have all of you had an opportunity to review that?
Yes, Your Honor. I have, Your Honor.
And are there any additions or corrections?
None from the defense.
Judge, my only thing that I would add, just for the court's recollection, and obviously I, of course, would not hold the court to this, we had some difficulty originally in getting her on probation. She volunteered a couple times. We kind of, based on her criminal history, made a stretch to make the offer. The court was inclined
Don't talk over her.
to go along with it based on some circumstances regarding her homelessness, etc. I do appreciate that she took responsibility for a motion. However, I have a note on my original plea papers that the state would be asking for primarily the max on the motion to revoke. But again, I know Ms. Holmes has an argument with some hard times that she's falling on, and I'm not.
Listen closely here. The defense is walking a tightrope. They're admitting the violations but leaning hard on the client's homelessness and lack of resources. In probation law, that's called mitigation. You're basically saying, yes, I messed up, but here's why it's not as bad as it looks.
I'm not ignorant of that. I just want to let you know my position, what it was originally.
I appreciate that, Ms. Holmes.
Yes, Your Honor. I believe originally that was my concern with Ms. Story essentially having probation was her lack of resources, in which she continued when she was placed on probation in February of this year. That came to fruition. She originally was at her brother's home. That didn't work out, and then she went to go to Liberty with a friend, and there was pretty much lack of resources, lack of transportation, and she made the decision to then not contact because she got scared, and here we are. Your Honor, my main argument is that she has not been on probation long to get started. She never has gotten started. Now that she's been in custody, they visited with her at the jail to let her know what steps and what resources that they can provide, so she knows that she does have help if she does fall on these hard times, that is what probation is for. We are asking if she could get that opportunity to get started so that she can get the resources and the help. She states that she's been in contact with her mother, and her mother would be where she would reside if she's reinstated back on probation to get things back on track. I do see in the recommendations that probation stated if she is granted reinstatement to complete the cognitive track of the intermediate sanctions facility, in which I've gone over that with Ms. Story, and she is willing to do that to have an opportunity to get back on track with probation. Your Honor, we do understand she does have extensive criminal history, and this is not her first rodeo. However, we are asking, due to the severity of how long she can be sentenced to prison, that she at least have one more opportunity to start probation and get back on track and get the resources that she needs.
I don't have anything additional, Judge. I defer to what the court deems appropriate.
I mean, what's appropriate is for you to go to prison for 10 years, probably, with your history and the fact that you got this chance in the first place, right? I mean, probation has all the resources to help you, but they can't go find you and force you to take advantage of those resources. That's up to you. You've been on probation. You've been revoked on every probation you've been on. So the fact that we gave you your probation now and that I'm even considering leaving you on it is making me question my sanity.
Whoa, that's a 10-year prison sentence dangling over her head like a legal sword of Damocles, and the judge just admitted they're questioning their own sanity for even considering letting her stay on probation. This is where things could flip either way.
Honestly. Do you have anything to say?
I'm so sorry for disrespecting y'all.
I mean, when you never show up, it's pretty much like you're just flipping us off, you know,
I understand.
for giving you an opportunity. And it's hard not to take it a little personal.
And I really am sorry. And I'm sorry for disrespecting y'all, and I will do it right this time.
What will you do different?
Everything.
Like what?
I'm gonna get me a job. I'm gonna go to work. I'm gonna go to probation. I'm gonna pay my fees. I'm gonna do everything that I'm asked to do.
Why didn't you do it before?
I didn't have a ride.
Well, but you could always call,
I understand.
right?
It's not my
You know, if you don't have a ride again, what happens?
I'm gonna use a phone call. I just had a granddaughter born, so
All right, I'm going to do this. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to continue you on probation. I'm going to order you to enter and successfully complete the cognitive track of the ISF program. You will be on 0 tolerance. If I'm telling you, I mean, if you are back in here, I really am going to see all of this. I see everything every time. And there's not going to be negotiations. There's not going to be, let's give you less than the 10. You've agreed to 10 years already. If you violate, it's 10 years in prison. And you can see your grandbaby when she's 5, 6, or 7 when you parole out. All right, so that's what's at stake, is a 10-year sentence. Not some lesser, maybe just 2 because you couldn't find a ride. You agreed to it, it's all.
Let's translate the judge's terms into plain English. Mess up again, and you're doing the full decade in prison. No plea deals, no sympathy. She even tied it to something deeply personal. Seeing her granddaughter grow up, that's high-stakes motivation.
All yours if you violate. Does that make sense?
Yes, ma'am.
All right, go back with the bailiff. Good luck. Jones.
Yes, ma'am.
And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And Mr. May. And in cause number 24 DCCR 2431 with the offense of unauthorized use of a vehicle. Mr. Wilkerson has filed a motion just in the murder case, correct?
Correct.
That I reduce the bond.
Yes, Your Honor. Which I believe is set at 800, if I remember.
Let me pull it up so we make sure. Let's see.
Misquote because I have had several of these.
It looks like in the motion it shows
Just the murder.
the murder is set at $800,000. And Mr. Wilkerson, do you intend to call your client or other witness?
Your Honor, I just intend to call my client and then also Venetia Jones if she is still present.
Mr. Johns, best you can, raise your right hand. Or Jones, I'm sorry. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can go ahead, Mr. Wilkerson.
Ms. Jones, you are obviously the same John Jones charged in this case with murder. You also have a companion case in which you are charged in a separate offense with unauthorized use of a motor vehicle. Is that correct?
Yes, sir.
And how long have you been incarcerated?
About 3-4 months.
And during that time, has that time you had the murder charges pending during the entirety of that time. Is that correct?
Yes, sir.
Now, the person who actually pulled the trigger with regard to this offense has pled guilty and been sentenced. Is that correct?
Yes, sir.
And that was to 30 years. Is that correct?
Yes, sir.
And he was on parole at that time, correct?
Yes, sir.
And until previously, at least as of the 24th of July, you had been off of 35, correct?
Yes, sir.
All right. Now, during the time that you have been incarcerated, you have had some run-ins with staff with regard to some behavioral issues. And obviously, if the court is going to consider lowering your bond and how you would be able to behave or would behave in the community at large, were she to grant a reduction in your bond, there are some concerns. And so I would like to give you the opportunity to speak to those concerns, and I would encourage you to emphasize conditions that the court might be able to impose that you would be ready and willing to follow that might curb some of those concerns for the court.
Pay attention here. The judge is probing past behavior in jail because how you act behind bars is often seen as a preview of how you'll act on release. And some of these incidents, they're not minor threatening to throw hot water on a guard. That's not winning any sympathy points.
All this case remains pending.
Yes, sir.
Go ahead.
Let me say, while the write-up thing was going around, I didn't have my proper medications, but I was supposed to be seeing a psych nurse to take my proper medications. And I feel like if you was to give me a bond reduction, and I was to get those recommendations, and I was to make bond, I would follow the rules because I take my medications now, which are for my anxiety, depression, and things of those nature. So I feel like a bond reduction is necessary, but
So you have your medications now?
No, but I should have them by the 21st.
So what, anxiety and depression don't make you say things like,
I'm gonna sit here in front of you. I never said those things, but
you didn't say those things?
no.
You didn't ask her how could she have a boyfriend with how ugly she was?
Never said that.
You didn't ask how many boyfriends she ever had? You didn't say any of that. They're just making that up on you, just lying.
I have to.
Have to be lying. You didn't threaten just a couple weeks ago an officer that you were going to throw hot water if she didn't call somebody?
Yes, ma'am.
You did threaten to do that? Okay. Did you... Did you say at one point when y'all were getting in trouble that what it had to do with somebody giving a Bible back to another person, and you inserted yourself in something that wasn't about you, and you said, that's what's wrong with y'all officers. Y'all think we on y'all time, and I'm not. So you don't think you're on their time when you're in jail?
I never said that.
You didn't? They made that up too?
What I said was, respect is given both ways. That was my exact words.
Respect is given both ways. And so you think you deserve respect with how you're acting. I got pages of incident reports. And it's pages only starting in June. We're talking about pages over just the last 2 months. Fighting. You've been in at least 2 or 3 fights, right?
Yes, ma'am.
Yeah. Mr. Coleman?
Your Honor, I have just a couple questions. Mr. Jones, what did you do with the weapon after Lenny Nixon was shot?
I gave it back to Green.
And when did you and Green decide to rob Lee and Nixon?
Objection, Your Honor. These questions obviously go to the guilt innocence aspect of
I
this.
think you opened that door when you asked him about the shooting and who the shooter was and the co-defendant.
When did the two of you decide to rob Lee and Nixon?
We never decided to rob him.
So if Green said you decided to rob him before he was shot, he would be lying?
I mean,
Yes or no? Yes or no?
yes.
Okay.
They be lying.
You knew the police were looking for you after Mr. Nixon had been shot, but nevertheless, you didn't turn yourself in, correct?
I didn't know. So
Okay.
after the fact, the next day.
When Lenny Nixon was murdered as part of this robbery scheme with you and Green, you were already under or on bail for UUMV, 2 cases of UUMV, and also a burglary of a habitation, correct?
No, sir. Never bailed out.
You were charged with those offenses, correct?
Yes, sir.
You
Three
also-
accusations.
All right. You were also previously arrested for assault on a public servant, correct?
Yes, sir.
Criminal trespass.
Yes, sir.
Another UUMV.
Yes, sir.
Evading arrest. Another evading arrest with a motor vehicle. That's all included in your criminal history, correct?
Yes, sir.
Who is Venetia Jones to you?
I'm
All right, pass witness.
Thank you. Go ahead, Mr. Wilkerson.
Yes, Your Honor, we've got to circle back over some of those. Just to be clear, Mr. Trevor, not Trevor, okay, Nixon was the gentleman who was shot, correct?
Yes, sir.
And you were staying at Nixon's house when Trevor Green came there, is that accurate?
Yes, sir.
And in fact, and Trevor Green initially told officers that you had discharged the weapon that had killed Nixon, correct?
Yes, sir.
However, even he corrected that statement ultimately and admitted that it was he who had the weapon, correct?
Yes, sir.
And on that evening, he took your phone, correct?
Yes, sir.
And he provided you the firearm that had belonged to Nixon, correct?
Yes, sir.
Now, you were asked about an agreement to rob Nixon of a firearm. And whether or not an agreement was ever reached. At what point, or at any point, and if so, how did you learn of Mr. Green's intent of removing or taking a firearm that had been in Nixon's possession?
It was about that morning. Well, I'm gonna say around that night, 1, 2 o'clock.
What do you, and you say around that night, 1, 2 o'clock, what is it exactly that you were told at that time?
Nixon keep pointing the gun in our face. Let's just take it.
And how did you respond?
Leave me out of it. I don't want no parts.
And so, just very briefly, you yourself, Trevor Green and Nixon, had the 3 of you grown up together?
Yes, sir. We all went to the same school at one point in time.
Now, Trevor Green had just been released from prison, is that correct?
Yes, sir.
And is it the case that Trevor Green was actually coming into town to spend time with yourself and with Nixon? And Trevor Green, when he came into town, he was with his girlfriend, is that accurate? Okay.
Okay, we're not gonna try the whole case. I gave you some leeway. I gave him some leeway. I'm not gonna listen. I understand there's obviously some differences in opinion as to what happened and who's culpable. So that's all going to be for a jury or for you guys to work out.
For just a couple more in a totally different direction, Your Honor?
Totally different direction.
All right. Now, you said you were getting your medications on the 21st. What medications are you speaking of?
I'm supposed to be taking trazodone, hydroxyzine, Brazosine, and they're supposed to be giving me another type of med for me hearing and seeing things.
So, while you have been incarcerated at Jefferson County Correctional Facility, the psychiatric or psychological staff provided by contract have made a determination that you actually have audio or visual hallucinations?
Yes, sir.
Okay. Your Honor, as a result of that, we will need to request...
Just file the appropriate motion.
Yes, Your Honor. I'll pass the witness.
I have no further questions, Judge.
All right. And you said you had another witness. Can you proffer what that witness would be testifying to for me?
Your Honor, that would just be his mother, Venetia Jones, and to the little bit of support that she would be able and really the inability to raise funds.
Thank you. Okay, thank you. And I'm glad she's here. Thank you. Where is she? Thank you for being here, ma'am. Okay, anything else?
Just a really brief argument.
Go ahead, sir.
I filed it, I put that argument, I made clear in the state's reply to the defense counsel's motion to reduce the bond, so I'm not going to belabor it. I just hit the high points, Judge. If the court is so inclined, the state constitution, the Texas Constitution allows you to hold this defendant without bond because he committed a felony while on bail for a felony, Judge. I've cited the case law. I've attached it to my reply.
I don't see that reply on this case.
It would have been filed on August the 6th of this year.
I see a couple of things. I see an order. Oh, never mind. It's right here.
Yeah.
Sorry.
I cite Article
Yeah.
Article 1, Section 11 of the Texas
Got it.
Constitution that states that if a defendant is on a felony, on bail for a felony and commits a subsequent felony, the court is well within its discretion to hold the defendant without bond if it so chooses to. And I've proffered to the court that I've spoken with the juvenile probation, with the juvenile department division of our office, and they have begun the process to certify this defendant as an adult, and that burglary habitation is on its way, should be making its way to your court soon, Judge. We've got the criminal history that I think speaks for itself. Your Honor, we'd ask that this court deny the defense counsel's motion to reduce the defendant's bond. In fact, if the court is so inclined, we'd ask that you hold him with no bond.
Thank you, Mr. Coleman. Mr. Wilkerson, argument?
Your Honor, I think that if you look at all of the incidents that were mentioned by Mr. Coleman, that are all juvenile incidents that have occurred with Mr. Jones, that it is quite clear in conjunction with some of the things that have also been mentioned, and also it fits into some of the write-ups that have been received as well, that Mr. Jones apparently does suffer some mental illness issues, and perhaps maybe we should hold this in abeyance until we can have that properly addressed in order to give the court some additional comfort that some of these behavioral issues might be more appropriately addressed.
Here's what I'm inclined to do at this time. I'm not going to hold the motion. We can always, if circumstances change, file a motion, and I will allow another hearing if there's a change of circumstances. Today, based on the nature of the offense, based on the amount of and nature of the incident reports from jail, based on the amount of and nature of the allegations of criminal history as a juvenile. Mr. Jones is 17, about to be 18, right?
Yes, ma'am.
So based on that, all of that, I am going to deny the motion to.
And there it is. Bond reduction denied. The judge just laid out the roadmap. Fix your behavior inside, and maybe they'll reconsider. Until then, Jones stays put. What do you think? Was the judge too harsh or just being realistic based on his record?
Reduce the bond at this time. Obviously, it sounds like the jail's doing what they can to get Mr. Jones help. If you want to file a motion with regard to any other competency of whatever you want to file with regard to that, get that filed, and I'll take a look at it as soon as it comes through. All right, you go back with the bailiff. And listen, Mr. Jones, whatever issues you're having, none of that, in my opinion, coincides with how you're behaving, right? So you need to make an adjustment of what you're doing in jail. And if you don't, then Mr. Wilkerson's not going to have any argument whatsoever for me to reduce your bond later or anything like that. So I've probably talked to just about everybody in that dorm, I think, in the last couple weeks about this behavior. Y'all can all continue to act like you're acting, and y'all can all sit there and wait for your cases and then go to prison or whatever happens. Or somebody can step up and say, I'm not going to act like that. I'm going to get up when I'm supposed to. I'm going to follow the rules. I'm not going to fight. I'm not going to call names. I'm not going to, all those things. It's not that hard. Just follow the rules. You may not like them. Follow them. And if you can't, then stay in there and keep doing it. Does that make sense?
Yes, ma'am.
All right, go back with the bailiff.